Hi, everybody, and welcome to our webinar. Today's webinar is on the Faithless Elector cases, and we want to thank the Supreme Court Historical Society for making this possible and the Hazen Polsky Foundation. And of course, we want to thank our guest, Zack Tripp. Zack is co-head of appellate practice at Weil. He is the former assistant to the Solicitor General at the Department of Justice. He has argued 11 SCOTUS cases. He's clerked for Justice Ruth Bader Ginsburg. Before going to the Assistant Solicitor General position, he worked for the offices of King and Spalding and Bancroft. He's been in the office of the General Counsel at the U.S. Department of Defense and the State Department. So that's a lot. So I'll let Zack say hello and welcome.
Hi, everybody. I'm really glad to be here. Thanks for having me. I've done the Street Law Summer Institute for a number of years, and sad not to be able to do it in person, but happy that I can participate here via Zoom as best as I can.
So to participate in the webinar, there are a couple things you can do. We'll just get the logistics out of the way. You can leave questions in the Q&A, and this would be our preference. We are going to look at the questions in the Q&A and see which questions have been upvoted and answer those first. So there's an option to upvote a question. When you go to leave a question, maybe glance through the questions that have already been left. If you think one is interesting, if one is very similar to yours, you can upvote it. You can also put in the comments if you have sort of an add-on to that question. The chat function, of course, you've probably all used chat before, and I'm actually going to ask you to use it in just a moment. So the chat function is sometimes under the More button, and that will allow you to talk to either just the panelists, if maybe you're having a technical problem, or to the panelists and the participants. You can also raise a hand, and that lets you to ask a question, allows you to ask a question immediately. So those are our options. And again, we prefer—
And please, yeah, just jump in. Like, please, the more questions we get, the more interesting this will be. You know, a big part of the reason we're here is to answer the questions that you have about these cases. So please participate.
Right. And I'm aware that what you're seeing is the slide and then the next slide. I wasn't able to troubleshoot that at the last moment. So maybe there's a time during the webinar that I can work on making that happen, but I don't want to lose time doing it. So I apologize if you're seeing the next slide as well. So we asked you already in a poll who is here today. So we have helping us behind the scene, Ben Marks, our communications coordinator, and Lillian, our law school intern. So maybe Ben can put up the poll results. And while he's doing that, it would be great if you could introduce yourself in the chat so everyone can see who's here and we can see who's here. Okay, so mostly Supreme Court Summer Institute alumni. If you're an alumni, it'd be great for you to tell us what year you participated. I haven't introduced myself yet. I am Kathy Ruffing. I work at Street Law now, but I recently retired after 27 years of teaching, and I attended the Supreme Court Summer Institute in 2002. And so I don't know if there are any 2002 alumni out there, but if there are, a special hello to you all. I can't remember which week I was, though, I have to admit. Great. Okay, seeing lots of familiar names. Hopefully you'll see some of each other. And yeah, and a lot of people, I'm seeing a lot of applicants. So unfortunately, of course, we had to cancel this summer, but we hope that the applicants from this year will consider reapplying. And some of the questions that are probably going to come up are, where do we get the materials? So there's a couple ways you can access these materials. There's a QR code there. If you just hold your cell phone up on the camera function, you don't even need a QR reader. And that will take you to a file with the PowerPoint. If you want to reuse the PowerPoint and repurpose it, a link to all of the materials that we're going to talk about today. And there is a bit.ly as well. That will appear at the end again. And of course, you can always email me if these things don't work for you. Okay, so we're going to jump into the meat of what's behind these cases, and that, of course, is the Electoral College. And for almost everyone probably on this webinar, it is somewhere in your standards to teach the Electoral College, and it can be very confusing for students. They can find it very difficult to understand. So we're going to walk through the Electoral College using this animated slide, which you are welcome to steal if it's at all helpful. And we're going to talk through the Washington state case while we do it. So in the Electoral College, of course, we know that the summer before there's even an election, the two parties choose their electors. So in Washington state, there are 12 electoral votes. They have 12 electoral votes. So the Democrats choose 12 electors and the Republicans choose 12 electors. And in the state of Washington, they have to say a pledge. They have to pledge that they're going to vote for the eventual candidate that gets elected in the general election. And they're aware at that point that they will have a $1,000 fine imposed if they break this pledge that they make. Not all states bind their electors in that way, but Washington does. And then, of course, in November, the people of Washington come and have a general election where they vote for the candidates. And as it so happens, in Washington state, Hillary Clinton and Tim Kaine won that election with 54.4% of the vote. And so it should be the Democratic electors who go to Olympia, Washington to vote. And they did, but 3 of our electors, our little purple electors down there, become our petitioners in the Washington state case. They vote for Colin Powell for president and 3 separate people for vice president, 3 different people. So those, as all electors' votes, they get sealed and sent to Washington, D.C. So after that happened, they were fined by the Secretary of State for Washington State $1,000 each for voting on, against the popular vote in the general election. So those votes get sent to Washington and counted. And of course, because we're mostly government teachers, we know that happens in January. And you need 270 electoral votes to win. This is what's behind our 3 petitioners voting not for Hillary Clinton. They were part of an effort to convince electors from both parties from across the country to vote against the popular vote in their state in an effort to make sure that President Trump did not get 270 electoral votes, and therefore that would throw the election to the House of Representatives, where one state would get 1 vote, and they were hoping for another result to the election other than the election of Donald Trump. That did not happen, however. You can see the red votes were the electoral votes for Donald Trump. He handily had 270 votes, and these multicolored votes over there on the right are faithless electors, maybe derogatory term, but the nickname that's been given to this group of electors. And those were the people who voted. And the 3 little purple people in the middle there, those are our petitioners in the case from Washington.
Sorry, go ahead.
I was just gonna say, so when we vote, as that chart shows, when you're voting, you're not really voting directly for the president. We all teach that it's not a direct election. You're voting for the presidential electors who will represent your state in the Electoral College. And I think only 6 state ballots actually have the word electors on the state, on the ballot, but Colorado, where our other case comes from, in this pair of cases, does have right on their ballot that you are voting for the presidential electors and not for the candidates directly.
I think one interesting thing I just want to mention about the ballot is I think this helps to crystallize the sort of voters' expectations. It's true that it says electors, but the people who are named on the ballot who you can choose from are Hillary Clinton and Donald Trump, right? Because there was just a candidate, there was just a huge presidential campaign, and this is the sort of the culmination of it. And the ballot doesn't even name the electors. It just names the people who the electors have pledged to support. And so, you know, it's this interesting sort of system where the Electoral College is there, and I think a lot of people know that, but at the same time, everybody expects that they're really voting for the president.
Great point. I love this slide because I thought your students might want to see the litigants here. And it also reminded me to talk about the gentleman's name. So his name is Peter Brett Chiafalo. And I believe that to be true because when you watch the Washington State Supreme Court, his advocate, Mr. Lessig, says his name several times and pronounces it Chiafalo. His name never gets mentioned in oral arguments at the Supreme Court at all by either side. But when Chief Justice John Roberts introduces the case, he calls it Chiafalo v. Washington. So my hunch is that it's going to go down as Chiafalo. But if you can watch, they actually do video recordings of the Supreme Court of Washington, and you can watch that yourself and hear him pronounce it Chiafalo. So I also thought your students might want to see Levi Guerrera, who was 19 at the time of the election. She was one of the other faithless electors, so very close to your students' ages. And then that is Esther John on the side. I left this slide in to the presentation. It's exactly what I talked about in the earlier slide, so we won't go over it, but thought it might be helpful if you did use this with students. I'm going to turn it over to Zach to talk about Colorado v. Baca.
Yeah, the Baca case is sort of a similar posture coming out of Colorado. This is Michael Baca. He was nominated to be one of the Democratic Party electors, and of course Hillary Clinton won in Colorado. And he took a pledge, like all the other Colorado electors, to support the Democratic candidate, but then when the time came to vote, he announced that he was instead he tried instead to vote for John Kasich, and so the state responded by promptly removing him from his position as an elector and appointing somebody else who followed through and did vote for Hillary Clinton, and then that vote got counted in the Electoral College, the one for Hillary Clinton. But then Mr. Baca followed up by suing Colorado and asking for $1 in damages, saying that he was not properly removed from office, that he can't be removed for the content of his vote. And so then that sort of teed up the process of these two separate cases coming up out of two different states at the same time, where one was about the validity of the fine, because in Washington State, they were each fined $1,000, whereas in Baca, it was a suit about the propriety of being removed from office. And we can go on to the next slide.
Yeah. So this is a generic slide, which we probably all have this flow chart somewhere in our textbook. This came from the street law textbook about the dual system of courts, how cases come up through the federal side or the state side. And ultimately, of course, we all teach that the US Supreme Court is the court of last resort, and that in theory cases can get to it from either one of these, and that it is from either one of these paths, and that it is a concurrent power of federal and state governments to establish courts and have cases go through. And then Zach's going to talk you through how one of these cases came up one side and one the other. So they're kind of a good teaching tool in that sense too.
Yeah, so the Baca case is coming out of the Colorado system, sort of works its way up on appeal. Mr. Baca actually won in the 10th Circuit. The 10th Circuit held that he couldn't properly be removed. And then at the same time, in a sort of a parallel stretch of litigation, were these Washington cases where Chiafalo takes up the fines and basically the state wins, the electors, the faithless electors lose. And then both cases go and petition the Supreme Court for review. And at the last step in the slide where it shows where you can come up out of a court of appeals or a state Supreme Court into the Supreme Court, as you probably know, the way you do that is somebody has to file something called a petition for a writ of certiorari, or a cert petition, which is really just a fancy word for asking permission for the Supreme Court to take your case. It is exceptionally difficult to get the Supreme Court to take your case. The Supreme Court has discretion. They don't have to take basically any of them. It's really a matter of discretion. And about 99% of cert petitions are denied. But the classic, most common pattern for cases that actually the Supreme Court up and takes are ones where there's something called a circuit split, where two appellate courts, state Supreme Court, have reached different answers to the same important question of federal law. And that's exactly what happened here, right? So we have the 10th Circuit in one hand held that basically Mr. Baca had constitutional right to vote however he wanted. He couldn't be removed for it. Whereas the Washington State Supreme Court said that actually, no, the state can punish you, albeit just with a fine for casting a vote contrary to your pledge. And so you get a circuit split, and both cases come up to the Supreme Court. And the case was granted in January and set for argument in April, which is sort of the normal schedule for a case granted in January, and to be decided. An April argument would normally be decided or by around this time of the summer. And then, of course, as everybody knows, in early March, the pandemic broke out and sort of turned the world upside down. And the Supreme Court canceled both the March and the April argument sittings. They stopped having in-person argument. And I think for a while, it really wasn't clear what was going to happen. And then the Supreme Court decided ultimately to hold oral argument in 10 cases, to do oral argument by telephone, and in 10 cases, and a number of the cases were cases that really had to be decided over the summer before the fall. And this is probably like maybe the best example of them. I mean, if the Supreme Court is going to decide whether electors are free agents with authority to vote for whoever they want, or if the state can control their vote, the time to do that is before a presidential election, not after it. And so the Supreme Court really needs to decide this question basically now. So it's one of the ones that got teed up. I'm just noticing a question from the Q&A, which is, why did one case move through the federal courts and one through the state courts? That's a great question. The answer is that so the Washington case proceeded in Washington court because Washington imposed a fine under Washington law, like initiated a proceeding to fine Chiafalo and the other electors there. So then it just worked its way up through the state system that was triggered off by the fine. Whereas Mr. Baca, when he sued the state and said, you owe me $1 for removing me from office, he filed suit under Section 1983, the Civil Rights Act, which allows you to sue state officials for depriving you of your federal constitutional rights. So that's how he got into federal court. There's actually a little bit of question in the case about whether his suit is sort of proper, whether he has, whether there's like a real 1983 suit when the only thing he's asking for is $1 in damages for something that's already passed. But anyway, if we go back to the oral argument. So, I mean, as somebody who argues in the Supreme Court, the development of the telephone arguments is like a fascinating shift. I mean, the paradigm for arguments in the last 30 years since Justice Scalia took the bench has been a very active peppering of questions from the justices who are often interrupting you and interrupting each other, asking sharp, very pointed, very perceptive questions from the bench. But there's not often an argument sort of time where it's really just one justice and you having a conversation. It does happen, but and another justice can always interrupt. Whereas with the telephone system, the way it worked was that the attorney gets a sort of a 2-minute opening, and then each justice has like a window in which they can ask questions of you. And of course, they can interrupt you. They're asking you the questions, but the justices aren't interrupting each other and each other's questions. And one of the very major shifts in this is that Justice Thomas has responded by becoming an active questioner. I think he probably asked more questions in the May argument than he had in the last 15 years combined. Asking very perceptive, sharp questions. And so that's just been an interesting thing to watch.
Okay, so we just wanted to make sure that you knew, and you're probably familiar, but that the fact that you can listen to oral arguments, all oral arguments at oralarguments@oea.org. And when you do, you get this kind of nice visual that has what the parties are saying, and if it's a justice who's speaking, they're sort of illuminated, like you can see Chief Justice Roberts sort of lit up there. And we also wanted to show you this because we want to talk a little bit about the way we organize today's presentation. So we were trying to decide whether to talk about all of the information from Chiafalo v. Washington, and then all of the information from Colorado v. Baca, or to look at all of the arguments and questions that were posed to the electors and all of the arguments and questions that were posed to the states. And we decided on the latter, and part of it had to do with the first question that Chief Justice John Roberts asked to both sides in the second case, the Colorado v. Baca case. In both instances, the first question he asked was basically, do you agree with your friends in the earlier case? And their answers were both essentially yes. So we thought it made sense to look at these arguments as the arguments of the electors and the arguments of the state. And maybe Zach wants to say a little bit about why these cases, which were originally consolidated, were eventually sort of divorced and argued separately.
Yeah, they were originally came up together to be argued as consolidated cases, and the opening brief was actually filed as like a joint brief, but then Justice Sotomayor became recused from the Baca case. So then splitting them up meant that she could continue to participate in Chiafalo. And that's definitely something that happens sometimes where the court, it's important for the court to be able to render a decision. And so having both cases helps to sort of increase the possibility that they're going to actually get an outcome here. So just turning to I think before we get into the oral argument, it helps to just like lay out what the basic arguments were on each side. I think a lot of this, I think it may be familiar to you, but basically the core argument that the electors were making in these cases is that, look, the electors are free agents, right? The whole point of this system was that it was indirect, that the states would appoint electors and then the electors would get together and choose who the president should be. And it's true that there's been a sort of a history of them taking pledges, but that's really just a sort of a moral authority and history. A custom is not a binding legal thing, and indeed states cannot bind them, just like a state could not force a senator, a federal senator or something, to vote in a particular way on a bill. And so they point in particular to, I mean, there's a lot of language, of course, in the text of the Constitution itself, Article 1 in the 12th Amendment, and just sort of founding era history, of course. And then if we jump to the next slide, I'll come back to this one in a second. The argument on the other side, the argument on the other side really for the states is that actually the Constitution only says that the states have the power to appoint the electors. It doesn't say how they need to go about doing that. And so it gives the states really enormous authority to decide what they want to do. And among other things, the states can decide to hold a popular election. They can decide to give a pledge, which the Supreme Court has already upheld in a case in the 1950s called Ray versus Blair. And they can make, you know, and they say along the same lines, we can make the pledge binding, legally binding, as we did here by removing somebody from office or by fining them. So basically the electors on this system are more proxies. They're not free agents. They're really proxies for the people, for the electoral will. And a big thing that's sort of looming over this case in the background is just like the practical reality of the way elections have worked in this country for the last long time. And the states point out that if the electors are right, that they cannot be removed from office for really any reason, which is the elector's legal position, then it means that you can't even remove one of them if they've been bribed. And so this, so they, you know, the states say sort of relatedly that, you know, if you had a close vote, this would basically cause chaos. It would be a huge invitation for foreign powers or the wealthy or somebody to, you know, to try to bribe electors and sway the election. And then, of course, the electors on the other side are trying to sort of diminish those practical concerns and say they're maybe not so bad, and also that really the Supreme Court just has to go with the constitutional design, even if there may be some downsides to it. So if we move on, can we?
So one of the things that's going to be great about teaching these cases is that you get to bring in Hamilton and Madison, who used to just be old dead guys, but now they're pop stars. And for those of you who teach AP, the tie into Federalist Papers is always important. So one of the things that came up, the terms that were used a lot in oral arguments, and Zach just used them when he outlined the case, were free agents versus proxies. So those terms come from, you can trace free agents back to Alexander Hamilton, and there's the quote, he thought the most capable of analyzing the qualities would be of a good president would be the people to choose, and those would be the electors. They would have lots of discretion. They didn't have, Hamilton didn't have a lot of faith in the electorate to make the right choice there, being uneducated and maybe uninformed, as opposed to Madison, who felt that they should be proxies and reflect what the people wanted. So their names get invoked a lot over the course of oral arguments, Hamilton and Madison, and the terms that the justices use the most are free agents and proxies. So you'll hear those as we discuss what actually happened at oral arguments as well.
Yeah, and also just I think one of the role of history and sort of practical concerns and like what to make of them are a really big part of this case. There's arguments on both sides, but the electors have, I think, pretty strong support from before, like right at the time, like immediate founding, maybe before the founding, but then very quickly states the party system came into being where you were really voting. There was voting in the states by the people, and then the electors were, going to support whichever party won. That system broke out very, very quickly. And so the justices are sort of trying to understand what to make of that and how that impacts the constitutional analysis. I guess one question from the Q&A was in Kansas, and each political party selects the electors. I think that is the common practice. So ordinarily the electors for each slate are, the sort of party people who are aligned very well with the interests of the party. But that's, I think the real question here is, when they all take a pledge, which they all do, can the pledges be made legally binding? So if we get into the arguments themselves.
There's actually another good, can we answer one other question from the Q&A now, because it's relevant? So there's a question that says, it seems like the electors, quote unquote, going rogue and voting as free agents causes an issue of one person, one vote. Does this case violate that principle established in Baca v. Carr? So if they really are free agents, are they violating that?
Yeah, I mean, there's actually some discussion of this in a way in the oral argument. The answer, I think, ultimately is no, because it depends on what you think the answer of this, what to make of the answer of this case. But technically, you are ultimately just voting for the electors. And so then the question here is, who controls what the elector's role is? And actually, the state's position, nobody thinks that the Constitution mandates that the people of the state pick the electors. The Constitution doesn't say that, and that's not mandated. The states have overwhelmingly done that. But I think, but still the idea that the electors may be breaking from the will of the people, we'll come back to some of that in the questioning, is a hugely important theme of the case. And, I think something that, the justices are going to care a lot about.
Okay, so as Zach sort of previewed there, we're going to take a look at first what the advocates sort of brought to the arguments, and then some of the questions that the justices asked. So I'm going to largely turn this part over to Zach.
Yeah, and in Chiafalo and also in Baca, the opening is very similar. This is just like right off the bat, their sort of 2-minute opening of the case is, do the states have the power to control our vote? And their answer is no. Look, the Constitution says, it calls us electors, and it says that we have the right to vote. And actually, there's all these very detailed provisions in the 12th Amendment about how we're supposed to get together and how we're actually supposed to cast the vote. And if they thought that we were just going to be like a proxy, an agent, or a minion, like these provisions seem like they're bizarre. The terminology doesn't make much sense, and it's just hard to square with the sort of setup envisioned by the text. And I think one of the interesting things too, and if you move on to the next slide, is in both of the openings for Baca and Chiafalo, the advocates for the electors said, like, look, and more or less said, look, you don't get to decide which is the better way to choose a president. Maybe this isn't the best system in the world, but this is the system that the Constitution envisions. And I would say that just generally speaking, as an advocate, if that's where you need to start, that's a tough place to be, right? Because you're acknowledging something that I think is important to acknowledge, which is that in order to be successful in the argument, but you're acknowledging that your position is sort of counterintuitive, at least in some way. And you're saying it's true that it's counterintuitive, but this is what the Constitution commands. Anyway, so then the argument in Baca started off on very much the same point. And then the argument gets underway, and it begins with the Chief Justice. Sorry, if we move on to the next one. Asking, and this is like maybe one of the most quintessential questions that you get in the Supreme Court, which is, what are the limits to your position? So the Supreme Court, most courts are trying to decide, like, in a suit between person A and person B, who wins. That's not what the Supreme Court is doing. The Supreme Court is trying to establish a nationwide uniform rule of law. The rule of law they're trying to figure out here is like basically can states control, prevent electors from going rogue? Can they make the pledges legally binding? And so when the Supreme Court hears somebody making their sort of like legal theory for why an answer is right or wrong, the Supreme Court always wants to know, like, what does that mean for some other case? What's coming down the pike? Is this a slippery slope? What are the limits of your position? And that was like right off the bat coming from Roberts. And the answer from the electors is our position is basically the electors can do whatever they want. The only limit they identified was that an elector has to vote for a human being. Giraffes were off the table. I think the Chief Justice's reaction to this is like, it was a little bit of disbelief, was like, that's not a limit, right? That's saying that your discretion is unfettered. And I think one of the challenges for the electors is that feels like the right legal position. It is a clear line. The Supreme Court could like easily adopt this rule. It's a nice clear line. It's easy to understand. But one of the reasons why the Supreme Court wants to know what exactly your position is because that they can ask you questions that sort of follow on from the sort of implications of what you're saying. And so the next set of questions, I think, are really the key follow-on to the point. If the elector's position is that their vote can't be controlled by the state for any reason, then the next natural question is, well, what happens if an elector has been bribed? Can you remove the elector from office for having taken a bribe? And the elector's answer to that is really no. It's like no with an asterisk. You could remove them from office if you were able to finish a criminal conviction before the time the vote would be cast. But in the real world, it's never going to happen. Like a bribery conviction can take a long time, and the bribery would probably happen pretty late in the day towards the time the the vote is actually happening, especially in order for us to like come up, it would have to be, you'd already have to know that it was like a close election, so that it would be very fast moving. And so that's, I think one of the big challenges for the electors was dealing with this, and then the sort of the natural sort of follow on to the question of whether there was a bribe is, but you know, the upshot of your position, if the electors can do anything they want and the pledges are meaningless, completely unenforceable, then isn't that, you know, a recipe towards chaos? Isn't this going to be terrible? Sort of a sky is falling type argument. And I think one of the challenges for the electors here is, and I think the advocate for the electors in the first case, a guy named Larry Lessig, who's a professor at Stanford, very impressive guy. And he answered, I think he did a nice job in answering these questions very candidly, but the answers are tough for him, right? His answer is I can't deny that chaos might happen. He says, I don't think it's a good possibility. There were elections for a long time, and this doesn't seem to have ever happened in the past, but he didn't have a way to say this wasn't going to happen in the future. And so that's, you know, when the justices have a concern about something, a lot, like part of what you're doing as an advocate is to try to make them less worried about the thing that they might have a concern about and trying to bring them some comfort. I guess, like, at least to me, it doesn't seem all that much comfort to say that I can't tell you that chaos won't happen. That's a tough line of argument. And then to follow this next one from Justice Kavanaugh, I think really perceptive and followed on to the question that we got in the Q&A was, you know, the electors have set this up as a dispute between the states and the electors, where the states are trying to control them and the electors are saying, no, the state can't control us. You know, we have this important constitutional duty. And Justice Kavanaugh points out, like, but what you're really saying is that you can disenfranchise the voters in your state, and you can break from the popular will, even when the sort of system is set up so that the voters are picking people who are beholden to them. That's like the setup that the states have established with the pledges. That's you know, and I think again, Larry Lessig's response to this was basically he said, like, yes, this could happen. I can't deny it. I guess one question from the comments: do we already disenfranchise when we don't give a vote to the popular vote winner? Why draw the line here? That is a great question. The short answer to that is the Electoral College, for better or worse, is still in the Constitution, and so that's where we're at. And the justices can't do anything about that. That they're boxed in by that. There were actually some questions about, there's something called the National Popular Vote Compact, where some states have gotten together. Aren't yet enough of them, but they've said that if and when enough states get together that it would be 270 votes or more, we agree to allocate all of our electoral votes to the winner of the national popular vote. And so it would be a means through the Electoral College to shift to like a popular vote system. And there were some questions from the Chief Justice and maybe one or two others that I took as actually implying that the Chief thought that compact would be okay, that states would have the leeway to do that. I mean, maybe I'm reading too much into that, but that's, you know, looming out in the background. But of course, I think the state's answer to a lot of this stuff too is that it's the states get to decide how they want to set it up, whereas the electors are saying that the Constitution mandates a particular system, namely that the elector must always be a free agent. So just to kind of come back to the questioning, Thomas had another one, sort of a similar question, like, what are the limits to your position? You know, if somebody comes in and instead of voting for the winner votes for Frodo Baggins, what can you do? Frodo Baggins being from The Lord of the Rings, and you know, again, the answer was like, well, Frodo Baggins is not human. And so, again, but otherwise, they really didn't have much of a limit. But one of the things that was quite interesting, if we go on to the next slide. So as I've been saying, that electors are the challenge a big part of the challenge in the electors' position is that they are saying there are effectively no limits on our authority to vote however we want, including you can't remove us even if we've been bribed. But the state's position on the other side was like equally categorical, and they said effectively we can do anything we want. We can set our system up all kinds of ways. We have complete control over your voting. We could design this any way we want. They really only had a couple of limits. They said we can't discriminate on the basis of race, can't add another qualification for office, like you can't say that you can only cast a vote for somebody who's over the age of 50 when the Constitution says 35, something like that. And then the state also said that they couldn't have like a bait and switch, that they can't change the system after the election. But either way, it is a pretty broad position, and so as they were saying, sort of off the outs, from the get-go, we have very broad power in this authority, including to remove somebody for violating the pledge or for being bribed, any kind of thing like that. And I think some of the interesting questions for the state side were, so the system has worked like this for a long time, where electors have taken a pledge and then the election has gone on. But actually, like, removing somebody from office and fining them is novel, and may have, I think, sort of depending who you ask, it may have either never happened before or been exceedingly rare. And so, Justice Ginsburg asked, like, why do you really need to do this? Like, isn't it enough? Like, your political parties are picking the people and they're taking a pledge. Like, can we just leave it at that? Like, how much of a difference will it actually make? The state's response to that was really sort of the chaos point, which was if you don't allow us to have control over it, the sort of the constitutional rule against us would need to be very, very broad. I think the next question, this is probably the next few questions, probably the rub of it for the state. So Justice Kagan said, what is your best textual argument? I think most ordinary people, like your students probably, if you just look at the text, you would think that this electors have flexibility. Like it doesn't say that flat out, but it does. There's a good amount of sort of contextual support for that. But the states have a good response to this, which is that actually the key point is that it is what it doesn't say, is that the Constitution doesn't say that we can't control their authority, and that the general rule of the Constitution is that states can do whatever they want unless the Constitution steps in and says that they can't. And so the states are sort of, it's a bit of an argument, kind of like the 10th Amendment, the sort of a federalism type argument. And so they're sort of relying on those kinds of principles. And then I guess Justice Kavanaugh asked the sort of next question, which was sort of where we started, which is, if the states are right that you can do it through the system where the electors must follow the will of the people, that they must be proxies, like, why do we even have the system? It seems really exceedingly bizarre.
Zach, do you want me to try to play the answer?
Yeah.
Okay. We'll see how this works.
Counsel, Justice Kavanaugh. Thank you, Chief Justice. Good morning, General. What is the purpose of having electors?
Thank you for that question, Justice Kavanaugh. When electors are set up in the constitutional design, that allows for states to make a choice. Electors can either vote as proxy voters on behalf of the public, as we do here in Colorado, or they can be free agents. By having this structure uniform across the several states, you give states the ability to choose which model they want.
But wouldn't, if that were the design, why not just leave it to the states as opposed to going through all these details about how the electors are supposed to operate? As you know, Justice Jackson and Ray looking at that history, said no one faithful to our history can deny that the plan originally contemplated was that electors would be free agents to exercise an independent and nonpartisan judgment as to the people best qualified for the nation's highest offices. That's the end quote from Justice Jackson. So that implies not a choice, but actually a requirement that the states give this kind of independence, free agent status to electors. And why go through all the details if it's the way? I guess what I'm asking more broadly is the text has all these details to set up a design that seems closer to what Justice Jackson articulates. Where in the text do you hang your hat?
Your Honor, our textual hook is the delegation of the authority to the states. By contrast to what Justice...
So bringing us also back to the fact that it's the state's decision.
Yeah. Yeah, and I think, you know, like as they often do in these Supreme Court cases, I mean, you know, it's kind of fascinating to me. I mean, this is such a fundamental question in a way about like the way our democracy works. And, you know, this incredibly important piece of electing the president. And it's remarkable that this is still an open question, right? That it hasn't been decided. And the, you know, the justices are grappling with this and grappling with the text and the history and sort of what to make of it all. You know, one thing I mentioned this earlier, and Justice Kavanaugh's question picks up on this, which is that this earlier case, Ray versus Blair from the 1950s, that I think a lot of people are not familiar with. This is not like a famous Supreme Court case, but it upheld the requirement to have a pledge. The Supreme Court said that a state could require the electors to take a pledge that they would support whoever was the winner of the popular vote in that state. That prompts like one of the next questions in the Q&A, which is like, what's the point of an unenforceable pledge? You know, and in Ray, the Supreme Court like deliberately refrained from answering that. They didn't answer the question, and so here we are now, 60 years later, grappling with that. But you know, that's one of the fundamental questions in the case. Like, if you can require them to pledge it, you know, you generally speaking, if somebody promises something and then they break away from that, you can maybe sue them for breach of contract, or maybe go after them for perjury, depending on the context. The Supreme Court in this case is not writing on a completely blank slate. And although Justice Kavanaugh is quoting from Justice Jackson in that case, Ray, that was Justice Jackson's dissent. And so the Supreme Court majority went in the other direction and said that you could require the pledge.
Before we jump into Q&A, so please add your questions to the Q&A if you have them. I'll just mention briefly that all of those, the answers to the questions, when you go to that material link, you can see out of the transcript of the cases what the justices answers were verbatim to those questions, if you're interested in what those are. Or you could listen to the oral arguments like we just said. Okay, yeah. Let's take some Q&A, and same thing, if you would just put them in there, and feel free to upvote the questions that you're most interested in. So I think the first one you've already talked about, what is the point of an unenforceable pledge? So this question is, does it come down to the winner-take-all system rather than proportional voting? Does that have anything to do with these faithless?
I mean, yeah, in a way, right? Because the question is whether the state can mandate a winner-takes-all system. That's one way of thinking about it, right? Really force the electors to go with the winner instead of breaking away and having some kind of voting on their own. Of course, there are states, you know, a big part of the state's position, they don't have to do it in any one way. And so Nebraska and Maine, I think, are two states that do somewhere in between, where the statewide winner gets some, and then the rest are sort of divvied up based on who is the winner in each congressional district. So it's broken up a little bit more. But I think generally speaking, at least these days, states are hesitant to divide up their electoral college votes that way, because it means that they just the candidates will pay less attention to the states. If they allocate them all in one block, I think it's more likely that the candidates will pay attention and campaign in the state and all of that.
Okay, how about the question, someone asks, so the state's argument is that their decision is political in nature. I guess there is the electors, and the Supreme Court has no authority to decide on it.
No, yeah, so the state's argument is that the choice of how to set up the, what to tell the electors to do is a political decision that the states get to make. Yeah, and that the Supreme Court has basically no say over it other than to just confirm that indeed the states have that exceedingly broad authority. I think sort of the flip side is the electors' position is it's a political decision. We are the electors say they are the ones with all the discretion, and that there's nothing the state can do to control them, that although it can force them to take a pledge, it has no authority other than just like a non-binding promise, like by a presidential candidate, not to raise taxes or not to do something, and then if they change their minds, there's nothing you can do about it. I guess one other question from the Q&A is from Lee. Hi, Lee. Do you expect the justices to divide along traditional partisan lines, or might this be a strange bedfellows decision? This is not, at least to me, this is not a case that has a sort of a natural partisan breakdown. There are a set of cases that when you look at them, you sort of you expect it is probably going to break in some way that is sort of left-right, more liberal justices on one side and the more conservative justices on the other. And that's true of a lot of the cases that like get coverage in the New York Times and stuff, the sort of most high-profile cases. This one, at least to me, it doesn't have that feel. It's not obvious one way or the other that this helps one party more than another. Anything could happen in future elections. This is a rule of law that is going to like presumably last until the Electoral College. Somehow there's a constitutional amendment or something to get rid of it. It could, based on sort of their different approaches to text and history and stuff like that, but I'm not expecting that it would break that way.
Okay, so there's a question about Justice Kavanaugh's question. And the question is there any current movement on an amendment to adjust the Electoral College, or were hopes just resting on the National Popular Vote Initiative? And I'll add sort of an add-on to that. Do you think that either of those things would affect the fact that they could be in the offing, or that they are options would affect the Supreme Court's decision?
Yeah, that's a good. I am not aware of like a real push to get rid of the Electoral College. The Constitution is just so hard to amend that amendments basically never happen. They are, just exceedingly rare. If you leave aside the Bill of Rights, which were sort of like part of enacting the Constitution, and then the Civil War amendments, there's not many left. But I mean, it is something you could imagine there being a push to do at some point. This is a little, I think there is I think right now there is some like a partisan layer, like there's a partisan interest in whether you would get rid of it. The Electoral College, I think on balance currently, I mean, this is the kind of thing that could change like in a couple of years, but currently favors Republicans slightly because of the way the numbers are composed. But I do not think that is true of the question here, which is like how do you go about allocating the electors, and how do you sort of go about deciding who is going to, whether it's going to be the people deciding or the elect. I have trouble seeing how that really cuts one way or another, beyond maybe the next election or something. And the justices all have, I think, a much longer term out than that. One of the questions is, when is the decision expected to be released? I mean, maybe next week, real soon. Traditionally, the Supreme Court, traditionally today would have probably been the last day of handing down decisions, and if this had been argued in April, it probably would have come down either like today or pretty recently. But with the coronavirus and everybody working remotely and May arguments, I don't think anybody really knows when the Supreme Court's going to be done with their opinions. And traditionally, one big factor in this is that at the end of the year, the justices all go on a well-earned vacation and often have like flights to Europe to go teach or something. And so there's like a real hard stop at the end of the term where, like, Justice Ginsburg needs to get on a plane, Justice Roberts needs to get on a plane. And that's obviously not happening this year. And so I think a lot of people are, really just don't know what's going to happen in terms of timing.
Okay, I'm going to take the last question, the liberty of asking the last question, and that is that even though we lump these cases together, one of these cases is about a fine that was imposed and a person had to pay, and the other one was about an actual removal where the person was denied the ability to cast the vote. So do you see a scenario in which they decide differently in these cases, where they fine for the elector in one case and the state in another case? I'm asking you to use your crystal ball.
I mean, I would say that it's unlikely, but possible. I don't think either side really offered up a theory by which you would treat the two cases differently. Like, the legal theories tended to be, you either believe that there are free agents over whom there can be no control, or you believe that the state has very broad authority to control them. And so under either of those theories, both cases would be answered the same way. But of course, the justices don't have to pick between the theories that the advocates offer, and they're allowed to come up with their own compromises. So, it's conceivable that the justices could say something to the effect that the states have the authority to appoint the elector, that authority may go in place until really the act of the vote itself. And so when they learned that Chiafalo was not going to do what they wanted him to do, when Baca was not going to do what they wanted him to do, then they had the power to just appoint somebody else to replace him. But you don't have the power after the fact to penalize them for the vote that they took. But I think it's fairly unlikely, because I didn't see anybody charting that path to them, and not clear to me like where the Supreme Court would come up with that rule. And it feels pretty thin. Like, if you can require them to follow a binding, if you can make the pledge binding in the sense that you can prevent them from voting, then maybe you should also just be able to penalize them if they break from it.
Great. Well, we want to wrap up by doing a poll of the participants to see two questions. How should the Supreme Court rule, and how will the Supreme Court rule? So if you want to take the poll, it would be interesting to see where you all shake out. Interesting. We're more divided on how they should than how they will. So we put you on the spot for how should they decide, but what do you think about the poll results for how they will decide, Zach?
I mean, like anything, I'm hesitant to predict these cases, but I think that's the way I would be leaning coming out of the argument. The combination of a sort of a long history of having elections work effectively, that the people pick and then the electors have to sort of follow suit, and these questions about bribery and stuff like that, that's real troubling. And it's hard to believe that the justices want to open the door to bribery at that level like being an effective tool to mess with our democracy. I mean, that's just not. I think they're going to be hesitant for to step in that kind of direction. So there are like a sort of a lot of historical support for the position at the time of the founding, but there's also been a lot of water under the bridge since then.
Great. So all of these cases and the information can be found on the SCOTUS in the Classroom website. You're probably familiar with it. We did the Title VII cases. June v. Russo was handed down yesterday. And of course, the New York State Rifle and Pistol Association, we have things for all of those cases. Probably most of you are either following us on social media or on our website or a news link, or you wouldn't have this, but there are the links to those things again. And of course, we would like to thank the Supreme Court Historical Society and the Hayes and Polsky Foundation for helping us put these on, and especially thank Zack Tripp, who put a lot of time and effort into helping us prepare for this and being graciously taking his time out to be here today and lending his expertise. So thank you so much, Zack, and thank you all for attending. I know it's summer, and we appreciate you taking an hour out of your summer break to spend it with us. And applicants, I hope you think about applying again next year. We'd love to see you in Washington.
Yeah, thanks. And thanks so much for having me. Thanks everybody for joining. I hope that was interesting and illuminating. I will make the pitch. You should, if you can, listen to the arguments, the audio. It's fascinating. You usually want to learn a ton about the institution and the people.
Great. Thank you all. Have a good night.